Three siblings on a deed. The first sibling, I'm going to call them A, B, and C. A, not married, no children. Elderly. B, not married, no children. C, married person. The way the deed is written, it uses the term, first of all, the deed is from 20 years ago. And on the deed, there's a typewritten portion, and there's a fill in the blanks. That's a typical deed. This particular deed also has handwritten language. It's not uncommon to have handwritten language on a deed. Oftentimes that'll take place at the closing. Say a person's name is Jane Doe, and they have the middle initial Z, and a person wants to insert the letter Z. Jane Doe says, hey, all of my identification has the letter Z. You know, my middle name is Zenith. I'd like the middle initial there. People will handwrite it, not people, the attorney will handwrite it in a Z, maybe with a little caret, and the seller will affix initials, and that makes it official. As long as it's done before the recording of the deed, afterwards that would be fraudulent, would be an issue, would be no good if you do that before. And sometimes people will insert other language such as joint tenants or right of survivorship. Say it was Jane Z. Doe and John Smith owners, and that's all it says. They might confer at the closing and say, hey, that's my sister. I don't want it to be joint. If I pass away, I want my heirs to get it. And the reverse, right? Jane might say that as well. Jane Doe, Jane Z. Doe. Now, this particular deed that I looked at today had the children A, B, and C, all adults, now all elderly. A and B are single, no wills. C is a married person. The way the language was written, their names were typewritten, and then there was language joint tenants, then there was other language tenants in common. I almost forgot where I was in the story. So when I read the deed, I understood it to be 1/3 each person. However, someone else had read the deed and thought it might be 50-50. And how could three people be 50-50? Well, I left that part of the story. It was A, B, and C. C was married. C's spouse's name was on that as well. So the way it looked was A and B, tenants in common. C and spouse, joint tenants with right of survivorship. So really, this deed is murky. It's murky because in this story, A passed away. A had a will. A left everything to B. B then passed away without a will. No children, no spouse, multiple siblings. 3 of these multiple siblings were on this particular deed, but who's going to inherit B's property? The surviving siblings, pursuant to an administration. And then C and spouse, I don't know them at all. They may or may not have a will. No proper estate planning. B needed a plan. And now, as I understand it, C, because of the way the language is saying that C and spouse should be entitled to 50% along with B. But I don't think that's the case. My reading of it was A's share went to B, pursuant to a will. B had 1/3, A had 1/3. They now own, B alone owns 2/3. That's my opinion, and we'll see, perhaps in a court of law, if that's the case. Properly plan. If you plan, if you have documentation that effectuates your plan, and we can avoid litigation. Let's try that, folks. Let's try that. Get a will, get a trust, prepare your documents in advance. It's helpful for all concerned.